supremacy. The Constitution of the Republic of South Africa guarantees fundamental rights to every individual, including those accused or even convicted of crimes. But this also raises an important and often emotional public debate. Are we striking the right balance between protecting the constitutional rights of offenders and ensuring meaningful justice, dignity, and compensation for victims? Now, there's a growing perception that substantial state resources are directed toward protecting and rehabilitating perpetrators through legal aid, incarceration costs, and correctional services, while victims often struggle to receive any financial compensation, psychological support, or restorative justice. Today, we unpack the constitutional framework, the realities inside district courts, and whether the system adequately serves both sides of justice. And a reminder to all our listeners, you can ask questions for our guests on our very simple number of 0609041056, or any opinions you'd like to share as well. So we are joined by the Judicial Officers Alliance of South Africa President Founder, Judge Neelan Carrigan, joining us once more. Good afternoon, Judge. Welcome back to the airwaves.
Thank you so much. I appreciate being here.
Good to have you, and I see you all nice and full of good attire and everything now.
Absolutely.
Hey?
As you can see, our memorabilia or whatever we need to have done, we've done. You've seen our banner, our branding.
Yes. Yeah.
And well, anyway, Immortal Hearts have generally been assisting us.
That's good.
And they've come to the party. Saisha in particular.
Fantastic stuff. Thank you so much. And let's jump straight into, we are very stuck for time here. So in the next 15 minutes, I want to cover very important topics of talking about balancing rights as well as justice. Now let's talk about our topic at hand. How should the justice system balance the constitutional rights of offenders with the needs and rights of its victims? Now, you as being a district court judge, how do you think the rights of offenders should be balanced with the needs of victims in our justice system?
You will notice currently the focus has been on accused persons and on detainees. That's where the bulk of the money and the budget ends up. When it comes to victims of crime, for some reason there has not been any prioritization on victims, in as much as we have compensatory orders that can be given in court. The vast majority of victims don't receive proper compensation, particularly for damages that they might have suffered. Remember, you look at the whole vast array of types of crimes that are out there. And when we focus on rehabilitation, we're looking at accused persons. We're looking at whether they need to go for some type of training, some psychological assessments. When they are in prison, they also get free education. They pick up a trade. So it's primarily accused or detainee-based support that's in place. And you must understand, we come from a very unconstitutional system, particularly when you look at apartheid. And if you look at the nature and the way in which accused persons have been treated, and if you look at the way political prisoners were ordinarily treated, with the advent of our constitution, all those anomalies were rectified and resolved, particularly when it comes to the way in which an accused person is treated, the fact that they have all these rights in the Bill of Rights that's immediately explained, the way they are treated when they enter the police cells after being arrested, and when they come to court, the manner in which they are treated, the way they are dealt with at the grills or the holding areas, and the way in which they are transported back to prisons for detention until their trials are ultimately finalized. Remember, it costs on average about 447 Rand per day per detained person, and people end up being in the system for years. Quite often it's a month, a week, but they can end up being there for years. So you can do the maths. It's a substantial amount of money that's invested in accused persons, and they are the offenders. Which is not a bad thing, because we want to rehabilitate and get them to where they need to be so that they can be reintegrated into society. So when it comes to their compensation and their care, their welfare, their dignity, their security, when you look at the Constitution, Section 10 and Section 12, those aspects, I think they largely been resolved. Now, what we have forgotten and we've neglected is the manner in which victims are compensated, cared for, looked after, from the time that they have to give in their statement when they go to the police station. You must understand that even our police stations are not effectively equipped to look after the victims, because it's largely victims that are coming to our police stations. They are coming to report crime, in as much as the system is in place for the criminal. But the victims that come through, when they come through, they need to be effectively supported, respected. And a lot of them have lost, not just in terms of physical injury, blood, sweat, and tears, and those types of damages that they might have claims for. They have physically lost money. They lost, whether it's a TV, whether it's a radio, whether it's a wallet. They could have lost anything. And with our house robberies, they literally lose the whole house. So when you deal with these types of aspects, largely, in as much as we end up convicting accused persons, sentencing accused persons, and they end up in our prison system, and they are covered financially in terms of how they are fed, how they are medicated, how they are treated, they are covered. But these victims, they are lost. They are lost into the system. Sentencing someone to direct imprisonment for a serious offense, that is some type of relief that they will get. But beyond that relief, they've suffered a loss, a financial loss. They need compensation. They need care. They need rehabilitation. They need counseling. Those systems are not in place. There are limited attempts to resolve these types of aspects. There's like Section 300 in the Criminal Procedure Act that allows for judicial officers to, in fact, make compensatory orders. But the issue is beyond that. Making a compensatory order, a compensatory order is largely done on a ad hoc basis. It's not a blanket thing. It's not as if you're a victim, you are automatically being secured. You are automatically being cured. You're receiving complete relief, where you need to actually be put in the same position that you were in prior to this assault, prior to this crime, because that's where we should be heading. We should be heading to full, complete restitution, and almost as if you should actually be getting some type of punitive compensation, because you've suffered something, and we sometimes refer to it as general damages. These victims need to be protected in this fashion, and we need to start working. And the solution is very clear. You start at the beginning. You always start at the beginning. You don't start at the end. And starting at the beginning implies that at a police station, when a victim goes there, whether it's a rape matter, or whether it's a theft or house robbery, whether it's a murder, because the victims include family members. Eyewitnesses are victims because they are exposed to this trauma and to this crime. So when you enter the police station, there must already be this mindset. There must be this mindset that from inception, the person taking the statement in the charge office, to the investigating officer, to the prosecutor who receives the case, to the magistrate, to the defense attorney, to the legal aid attorney, all of them need to understand and appreciate that this system of victim support, victim empowerment, victim compensation must always be an underlying thread. I was just having a discussion with a former Minister of Police, General Becky Kele. And Becky Kele has also been very passionate about victim support, victim involvement, because he appreciates the system. He appreciates the system where we focus on the accused person, the detained person, and he's very mindful about those individuals that are victims, but they are left by the wayside. So when I talk about compensation, at the outset, there must be some type of understanding that as we move along in the investigation, as the investigation concludes, as the trial starts, until conviction, until sentencing, those victims, those witnesses, they need to be part of the value chain. They should not be a side issue. They should never be an afterthought, because right now, victims are afterthoughts. And largely because we postpone matters so often that these matters, in fact, these witnesses end up not coming to court ultimately, because they've been coming to court 3, 4, 5 times, whether it's the court that is postponing for some apparent reason, whether it's a prosecutor that's not prepared, charge sheets are not drafted, investigations are not completed, investigating officers are requested to do certain things and they don't do it. So that whole chain causes a delay, affects the victim, because if we operate efficiently, we should be able to, on the first date of trial, actually run the trial. Because why would I set the matter down for trial and I've certified the matter trial ready? So that's also part and parcel of the empowerment of the victim. When the victim comes there, the complainant comes there, the complainant testifies, we need to be able to dispose of that complainant so you don't come back, because there's a cost. You have to travel, you are working, you could be a professional, you could be a doctor, you could even be just a general worker, but there's a money aspect. Quite often, the victims that come to court, they don't even get paid for the day, wherever they are. They suffer a loss, a financial loss. And our system doesn't compensate for that. They might compensate you for using the bus or traveling to court. You know, there's witness fees. But that is not proper and full support for the victim.
But just to add to that, I mean, why do you think the system is like this, and why after almost 30 years of democracy that this is a topic of discussion only now? Has it been a discussion in the past where you can say, you know, this is the flaws in the system? You're saying that, you know, as you mentioned, the offender gets a sort of state money based on a 400 rand per day in prisons, I think you mentioned, where it works out over 12,000, 13,000 a month, compared to, as I had information with regards to social grants, only give 350 for the month. So
Absolutely.
it just it's chalk and cheese at the end of the day.
It's very disjointed,
Yeah.
because you see, in terms of our constitution, we're all rights-based. And rights-based, we tend to focus on the accused person because we want to make sure that as we move along in the criminal justice system, we want to make sure that we tick all the boxes. And ticking all the boxes implies that we must ensure that this accused person is fully protected in terms of right to remain silent, right to legal representation, to get legal aid attorneys on board, whatever rights we need to give him. Because if we don't follow due process, then there's an irregularity. Then that conviction can, on review, potentially be set aside because maybe the police officer didn't even explain rights and there was a voluntary admission of guilt, or there was some type of a confession made. So the processes have to be done strictly and to the T. Okay, so the priority is there. The victims, unfortunately, they appear to be not prioritized. And when we talk about 31 years into democracy, remember, we have a lot of flaws. We've spoken about our single judiciary and the fact that we don't have one in the country, and we're disjointed.
But isn't the protection of the victim also adds to the, as you mentioned, you highlighted all the priorities of the actual perpetrator. Doesn't it also fall in line that the a victim also needs to be of sane mind to sort of testify in court based on the whole incident? Doesn't that work hand in hand?
You're absolutely correct.
Yeah.
Unfortunately, it has not actually happened. There is this attempt to achieve that. When it comes to the victims, you can see clearly that there is no balance. There's no balance because it's largely a new thing. It's a new thing, but it's in the Constitution. We cannot say that there is some deficiency in our Constitution, because when you're looking at dignity and you're looking at security, I think we already appreciate that it equally applies to complainants. So what we need to do and what we need to develop is a culture within the criminal justice system that ensures that the victims are properly and effectively dealt with. And, you know, in some countries, like I understand in the UK, they are victim empowerment funds. Like how you get the road accident fund.
Yes.
Those are types of funds that we need to seriously consider for victims, because victims should be receiving some type of compensation. We're not giving you some type of award or salary or some type of benefit. The compensation is merely to maintain the status quo, to allow you to be placed in the same position you were at as before the crime. Yeah. Exactly. So there must be a system for that to happen. And it's unfortunate that we speak of monetary terms, because this largely deals with money. But beyond money, when we talk about victim empowerment, we're going to need counseling. We need to have active participation in the rehabilitation of the complainant to achieve and to work through the trauma that would have been suffered. Look at a rape victim. How do you put a value to that? And where does the money come? And how do you decide that this rape victim will get 10,000 or 100,000 and the other person some other amounts? And then you look at the accused person. The accused could be a millionaire and potentially can afford to pay proper compensation. And it could be a person of straw that has no money. So we need to appreciate, therefore, that idea of a victim empowerment fund. It's a very important direction that I think, as the Judicial Alliance, we are going to push and drive that agenda. No, we're going to drive that agenda unapologetically, because it's important. It's relevant, because if there is a fund, then technically the complainant whether they win the case or not. Because you must understand, to prosecute someone, you just need to have a prima facie case. That doesn't mean I'm going to get a conviction. The person could be acquitted, but he could quite easily be guilty of the offense. And for us to take a case, for the prosecutor to take a case and run with it, it means that they appreciate there is a case here, and it's prima facie, a solid case here, and they run with it. So that victim, in as much as a conviction might not be secured, still needs to have some compensation. The test is not beyond reasonable doubt that this complainant must come to court and prove anything. I mean, there's a prima facie case on the balance of probability. The version seems to be correct. So they need some type of compensation and type of relief. So I think it's important. This empowerment fund that we speak of goes beyond having the prosecutor to drive this process. And then you get a junior prosecutor who does not understand the concept and would not even put that through. Remember, we get victim impact reports when it comes to sentencing, where the victim will come through and maybe hand a statement or even testify in court in aggravation of sentence. Sometimes they can even testify in mitigation of sentence, where there might have been an apology or they didn't want to proceed because they received some compensation. So it has an impact on the sentencing and the thought process for the judicial officer. As a judicial officer, when I'm sitting in a murder case or a rape case or a housebreaking case, those are dynamics that are important to me, because if there is some type of restitution and rehabilitation or mediation where there's some issues that have been resolved, it makes it easier for me to sentence, because I don't need to throw the book at someone. Because we need to have a deterrent effect, we need to protect society, we need to rehabilitate. Those are all the considerations I need to consider as a judicial officer when I sentence. I need to look at the magnitude of the matter, the injuries that were sustained, how deep was it, what's the impact on the family and everyone around. So it is so vast. It is not as if I can tell you for rape, you're going to get 100,000 or 50,000 or 5,000. For murder, for the family members must get a certain amount. But you get
where do those funds come from?
It comes from nowhere currently. Remember, right now, the victims technically have always a civil case against any offender because of damages suffered, whether it's actual loss or general damages, pain and suffering. I mean, if I'm suing you as a rapist, and I'm the complainant, I need to quantify. And it's a thumb suck, and the judge, whoever it might be, needs to quantify your pain, your suffering, your injuries, what type of trauma, how did it affect you? Were you married? Did you have children? Was it done in public? Was it done in front of some other people? Was it a gang-related rape?
So those factors
will be a consideration when I talk about quantum, the amount. And as the judicial officer, I'll have to factor it. But this is a civil aspect I'm bringing in. I'm just raising it because complainants always have a civil claim that can run concurrently with a criminal charge that they're working through the prosecution, through the investigating officer, and hoping that the magistrate, depending on the quality of the evidence tendered, will actually sustain a conviction. Because imagine going through the trauma, having to see the accused person, because we have our open courts. And remember, our system is quite adversarial, not necessarily inquisitorial, which means the accused person has a right to challenge and look at the complainant and question ordinarily. Although we have CCTV areas where victims can be kept in a separate room to avoid proper contact. That's some type of protection we give them. Or when children are witnesses, we have that system in place. But in our courts, we don't have adequate systems. Not every court has that facility. Quite often, I will have to wait for another court to become available for me to use that child witness. And when children come to court, by 10, 11, 12 o'clock, they're already tired, they're sleepy, they're hungry. So as judicial officers, we have to prioritize those types of witnesses. So that's also part of the empowerment process. Even women, irrelevant of them being children or adults. If they're adults, they still sometimes need that protection because they can't survive or sustain that trauma. Every court must have those facilities, and we don't. In Randburg Court, that's where I'm based in Gauteng, we have, I think, just about 2 courtrooms amongst all the courts that have an effective CCTV system. And within that system, sometimes they don't work. Our stenographer machine, recording machine doesn't work. Then what happens to the case? You set it down for trial. So we are abusing the victim indirectly or unintentionally because the matters are getting postponed. They must come back.
Now, you mentioned that, it's the basis of everything that's been spoken here this afternoon is the factor of money, as you mentioned,
Yes.
and it's obviously you're looking at sort of state money to implement something like rehabilitation or victim empowerment. Since this has been an issue, which I'm sure this has been raised in the past many a times, has there not been any third party sort of step in saying that, you know what, this is something that needs to be done. We are willing to donate. We are willing to put something together. Has it not been proposed before, or has it been not of a legal way of actually making it come about?
To my mind, there's always been NGOs, non-governmental organizations, civic societies, different legal entities and groups that on a ad hoc basis, fill in the gaps and try to cover certain niches. And they are there to assist. Church organizations or religious organizations, they get involved because they're largely community-based. But that's done on a voluntary ad hoc basis. They cover certain aspects, but it's not done across the board. What we are speaking about as the Judicial Alliance, we are speaking about across the board. It must be a system. And you as the complainant, you don't have to claim from the system. I mean, if you don't need it, you just want to get your pound of flesh, or you want justice to be done, you just want to be heard, you won't need it. But you get those complainants that actually need that support, because that crime, whatever might have affected them, because they maybe can't go back to work again, they're so traumatized, or they won't go to work for a certain period. Those are the victims that really need assistance, they need empowerment, and that's where we need to sit and deal with this in terms of a fund of sorts. However it's structured by government, wherever it comes from. I mean, if we can spend so much money on the road accident fund, they got billions and billions of rands, and they still get bankrupt. And they still get bankrupt, whether it's mismanagement or whatever, I don't know. But we need that type of funding for the victims, because it will help society. We can't have our complainants going back home in a broken state, but you've got a conviction. So what have we done? I mean, how do we follow up with these victims that come to court were affected by crime? If we look after each other and, really look at the way Ubuntu operates and the culture of reconciliation and, coming together as a society, if we can start thinking like that, then we'll appreciate the importance of this, because we never had it before. So we just cold hard people. We just let it be. And I think we're going away from that. We want to be united. We want to be solid. We want our victims, when they come in, they must know this is their space. They must not be an afterthought, be in the passages with accused persons and be intimidated. The way our courts are structured, our victims must be prioritized, not accused persons. Accused persons, I think they've had their day. And I was talking to you about the Criminal Procedure Act. Right now, there is this drive to amend the Criminal Procedure Act, because an accused person has a right to remain silent. And a complainant will come and testify. And the accused person can just say, I'm remaining silent, I'm closing my case. And there's so many technical laws involved as to whether there was a prima facie case, whether there was sufficient evidence before the judge who must convict on beyond reasonable doubt, not even on a balance of probability. I'm not saying there must be no doubt, but it must be beyond reasonable doubt. Now, the Criminal Procedure Act is going to be changing, and I'm supporting it fully. And as the Alliance, I believe that we will be supporting it. An accused person, if there's a prima facie case and you have already been brought, whether with a warrant, J50 warrant, or whether there's a summons issued and you're coming and you're facing criminal charges and the complainant testifies, you should not, as an accused person, to my mind, have a right to remain silent. Why can't you explain? You're innocent, give your version. Because if you remain silent, what does it tell me? Must I just be forced to draw a negative inference? Why must I be doing that? I shouldn't. I must allow you to speak. Just as you question the complainant, you must be cross-examined by the prosecutor. You must give your version. So the Criminal Procedure Act is going to become, and as I say, as an alliance, it's going to be supported. It needs to become more inquisitorial. Inquisitorial is where the court mostly engages. And when the court engages, the court has some latitude to maneuver, because the court knows what it needs to sustain a conviction or to acquit. Because if your version is reasonably possibly true, although you're likely guilty, but if it's reasonably possibly true, I got to give you the benefit as the accused person. So I'm not taking away any of your rights. I will acquit you because the court or the prosecutor has not proven their case beyond reasonable doubt. So if they haven't, then I'll acquit you, although you are probably guilty, because the standards are still there.
Yeah.
So I'm not prejudicing you.
Yeah.
So the Criminal Procedure Act, to my mind, is going to be driven in a fashion that's going to talk to victim empowerment, because a victim will feel empowered. I've said my piece.
Yeah.
But that man didn't say a word and remained silent and got acquitted. He should have said what he should have said.
Absolutely. I think on that note, we can end it off there, Mr. Judge Neelan. I think that's a very informative, very enlightening, and very educational sort of segment. I've learned a lot about the system. I'm sure the listeners as well taken aback with this conversation, and I'm sure, I would have had tons of more questions. I'm sure this conversation went on for hours, but it's like I'm learning law. I'm learning law firsthand. But thank you so much. It seems that just to sort of concise our interview is that the system is flawed. It's working in an archaic a system that doesn't work in favor of the victim, but more of the offender. And you are here to obviously sort of voice that and be vocal about it and to make sure that the system changes in light where the victim gets empowered. And obviously, it's justice at its best, I think. Yeah. Judge Neelan, thank you so much.
I appreciate the opportunity. I appreciate the platform. I appreciate the traction you are giving to the Judicial Alliance of South Africa, comprising judicial officers. And I'm very mindful of the good work that your radio station is doing.
And thank you for being a
much
part of it
appreciated.
as well. Thank you for joining us once again. And thank you to Ash as well. Ash, did I get your thumbs of approval? There we go. Thank you so much. That was the president and founder of the Judicial Officers Alliance of South Africa, Judge Neelan Karikan, joining us here in studio talking about the justice system or lack thereof. And we're looking forward to having you again in the near future. It's time for us to go for a quick break. And then we have Sister Fadwa Bully joining us for some enlightenment here this afternoon for the month of Ramadan. Stay tuned.
Welcomes your feedback. If you have a broadcasting related complaint,